Donald Trump submits for subpoena, sending these over to Judge Chutkan. Of course, this is in the January 6th case out of Washington, D.C., and we see a bunch of people on the subpoena list. Now, this is what the court docket looks like. You can see right here. Look at all these attachments. The main doc will read, then all the attachments. Boom, 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 boom. Subpoena, 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 subpoena. But before we can understand the subpoenas, let's see why Donald Trump's team is requesting them and what they think is the appropriate argument to the court. They've submitted this out of the District of Columbia, Judge Chutkan presiding. You see, it's the United States of America versus Donald Trump. And here, it's President Trump's motion for pretrial subpoenas with an accompanying memorandum of law, which we'll read through now. They say, Your Honor, Judge Chutkan, President Donald John Trump respectfully requests leave to issue the attached subpoenas duces tecum, hereafter known as the requested subpoenas. And duces tecum is a fancy word for saying with documents, bringing with documents, or show up and bring the papers. Bring them with yourself, I think is the actual Latin. So it's to someone, but it's you got to bring this stuff in front of us. And they're requesting leave, which is permission. You know, Your Honor, can you sign off on these subpoenas so that we can go and send them for these people? And they want this for the pre-trial production of records. So oftentimes here on this channel, we talk about subpoenas and they're for somebody to show up at trial. For example, in the January 6th case, we were asking ourselves, where the heck is Ray Epps? Anybody know where he is? He got a subpoena that, in my opinion, he was dodging. They couldn't serve him, and so they couldn't bring him to trial. They wanted to cross-examine him, but that's not what we're talking about here. This is pre-trial. They don't necessarily want these people to show up. They just want some documents, and we're going to see why. So here are the following people that are going to get these subpoenas, and we're excited about this list. The Archivist of the United States of NARA, the head librarian. Now, this is no longer Deborah Stidel Wall, and this is a new acting director, which is Colleen Shogan, as we'll hear from in a minute. We'll see she gets the subpoena. But this is a critical entity in this entire saga because they're the ones who theoretically turn the key on allowing the DOJ to access what they needed to access in order to bring the classified documents case. We're in Washington, D.C. right now, but NARA was involved in all of these things. Okay, NARA, as we're going to see, is involved of the January 6 documents, but also the classified documents that allegedly Donald Trump stole illegally. Even though he didn't, even though they're his under the opinion clause power of the United States Constitution. So this is a critical keystone, as it were, that is very important in this entire saga. So NARA's going to get it. The clerk of the House of the Representatives. And some of these people are transactional. So not necessarily that they're nefarious, not necessarily that the clerk was like involved in this grand conspiracy, but they were just mechanical, right? They just might have gotten the records, or they were there, they saw it, they witnessed everything right in front of them. So he gets one. The current Committee on House Administration, which is the successor entity to the J6 committee, right? So we're going to see some Republicans get subpoenas. And we're going to say, why are Republicans getting subpoenas? They were like on the same team. Well, it's because they inherited the January 6th Select Committee. Liz Cheney got her butt thrown out. And here, January 6th Select Committee has been now, their record's supposed to be handed up and delegated off. We're also going to see Richard Sauber, Special Counsel to the President, Joe Biden. We also have Jonathan Meyer, General Counsel to Homeland Security, is going to be getting a subpoena. Representative Barry Loudermilk, also from the U.S. House of Representatives. And Fishing Bennie Thompson, the same guy who we spent, oh gosh, I don't even know how long here talking about, because he sent subpoenas to everybody. He sent a subpoena to his wife. Honey, don't forget to get milk on the way home. It's like, gosh, this guy, calm down. And I think Liz Cheney was really behind the whole thing. I don't think really Bennie Thompson really cared much at all. So the House committee has identified these records that we need, Your Honor, as missing from the archived records of the January 6th Select Committee. And so by these subpoenas, President Trump seeks to retrieve certain missing records and uncover information about their disposition. What happened to all those missing records? Where'd they go? All from these individuals who were involved in it. And so you also think about this like chain of custody, right? Where'd the records go? They're missing. And so we need everybody in the chain, which happens to be all these people. So, Your Honor, here is our memo. They say, Dear Judge Chutkan, President Trump is charged with conspiracy to defraud the United States. Also, conspiracy to obstruct an official proceeding, attempt to obstruct along with obstruction, and conspiracy conspiracy against rights. Now, the false allegations, Your Honor, this is Trump's defense writing, they carry a focus on the certification of the 2020 presidential election, and they encompass the period between the election held on November 3rd and January 6, 2021. So they're putting some bookends on this. All right, Judge, just so we're clear. You know, he's been charged with 4 counts. Here, conspiracy, obstruction, and another conspiracy charge. All of the conduct described here that's illegal happened, allegedly, within these 2 bookended periods. So as the court is aware, Your Honor, a House of Representatives committee called the January 6 Fake Select Committee that was illegally constituted under H.R. 503 by their own rules. They're even referencing the House resolution that authorized them. Not authorized because they did not have the appropriate requisite members that they said that they would have. So by their own rules, they were illegal. But anyways, committee previously, they investigated this with Liz Cheney and Bennie Thompson. The Select Committee compiled a large archive of information, and they brought out people like Clavicle Girl to lie to all of us. The Select Committee, in a footnote, purportedly they accumulated 4 terabytes of data during the investigation, which is a lot. But Representative Loudermilk, as we'll hear from, he's getting a subpoena in here, he reported that his successor committee received only 2.5 terabytes. Well, isn't that curious? What happened to 1.5 terabytes? Gone. That's a lot. It's almost half the data. It's gone. So what would you do the math on that, right? 40% of the data? Oops. Don't have it anymore. So they purportedly accumulated that. So, you know, they've got 4 1-terabyte hard drives that you're expecting. You show up at Liz Cheney's office. All right, I need 4 hard drives. She's like, sorry, best I can do is 2.5. You say, what? What is this? Sorry, we're in charge. So that's what they're asking for. So that's a lot of data. Now, upon the dissolution of the Select Committee at the conclusion of the Democrats' Congress last session, applicable House rules required that the Select Committee, Liz Cheney and Bennie Thompson's, that they transfer its records to the Committee on House Administration so that the next committee has it, so that they can preserve it and archive it because their review is concluded. But according to a letter from Representative Barry Loudermilk, who is the chair of the Subcommittee on Oversight, he says that Liz Cheney's Select Committee did not transfer or archive numerous records, collectively known here as the missing records, according to the Honorable Barry Loudermilk. Now, we have that letter. Here is what we see that was sent back earlier this year, June 26, 2023. This one went over to the Honorable Bennie Thompson, signed, as you can see, by Barry Loudermilk, the gentleman we were just referencing here in Congress's letter. This is to Bennie Thompson. He says, hey, dear Bennie, you know, look, I write to you today in your capacity as the former chairman of the Legal Select Committee. As you're aware, I chair the committee that's supposed to have jurisdiction over the safety and security of the Capitol. Now, all committee chairs have a responsibility, that includes you, Bennie, to archive non-current committee records at the end of each Congress. Okay, it's House rules right here. Rule 7 of the rules. Right there, Bennie, follow the rules. It is the chair's responsibility to transfer the records to the clerk, who then stores the records with NARA. So we follow the bouncing ball. We follow the chain of custody, which is why Trump's people are doing the same. The resolution establishing the Select Committee added an additional reporting requirement by mandating that all records of the committee could be transferred to any committee designated by the Speaker. And so, of course, when they created this, they created their own records rules so that they could do what they wanted with them. Now, in the Congress, the rules reiterated that they would be transferred to House administration. Okay, after they passed it, they didn't know that they were going to lose Congress, so they passed it and it goes to House administration. So that's where Barry Loudermilk is now. He says, okay, Bennie, as part of my oversight responsibilities, I got these records and my staff and I have reviewed the records that we have received. Now, as you can imagine, Mr. Thompson, I was concerned to discover that some non-current records were not archived despite the requirements of the rules that were established. The video recordings of the transcribed interviews and the depositions, which were featured prominently in your hearings, were not archived or transferred, okay? Only the written transcripts were provided. So all of the videos of everything that they did, which is why you record them, okay, nobody believes a transcript because you can change it. That's why you transcribe a video, so you can reference it. So it's clear that nobody believes the transcripts, all right, first of all. And secondly, we've read the transcripts and they are terrible. They are some of the worst concocted transcripts that you've ever seen. It's like somebody was typing with their forehead. They don't even, in many of these interviews, articulate who was asking the questions. There's multiple questions lined together. There's like compound questions, and then they allow the other person to say whatever they want, and then they can pick whatever they want out. So they deleted the videos and the audio recordings. They didn't archive them because it probably would contradict what they wanted to write in the transcripts. So it's a disgusting deletion of evidence, right? In a real country, in a criminal case, if the government deleted evidence that was against you, honestly, their case would be dismissed ordinarily if you weren't practicing in Washington, D.C., and the prosecutor would be reprimanded or disbarred, right, for deleting evidence that you're entitled to, actively, knowingly, in violation of the rules. It's a disgusting thing that they've done, but they did it. So furthermore, you sent a letter to Mr. Richard Sauber, special counsel to Joe Biden, on December 30th, 2022, Benny. In the letter to Joe Biden's lawyer, you stated that you cannot ensure the enforcement of the commitment to maintain the confidentiality of the identity of the witness. You go on to say that you were returning the transcripts to an undisclosed person or place for appropriate review and timely return, and then designation to proper handling by the archives. You also said that Nancy Pelosi allowed you to do that. You then also sent a letter to Homeland Security. And in this letter, you also referenced information that you got from some unnamed Secret Service witness. You noted that the Select Committee was dissolving and that you cannot ensure the enforcement of agreements. And so, like, the Republicans are going to honor their agreements. The Republicans are going to get their hands on this, in other words, and they're going to go hog wild. So before we save this file, delete the stuff that you don't want saved. Guess what? We wake up and 1.5 terabytes have been deleted. So according to your letter, you coordinated with, again, Speaker Pelosi, the same woman who said, "I've been waiting for this," when she was being recorded by her daughter during January 6th. No version of the letter to Mr. Sauber, either redacted or unredacted, or the letter to the general counsel was archived. So Benny sent letters to his compatriots and then deleted the evidence. Additionally, there is no explanation of what transcripts these letters are referring to, or why you, in coordination with Pelosi, did not immediately archive the records with the clerk. They deleted all of the January 6th evidence. The bad stuff. The good stuff that served their fake narrative, they left, but they had the Biden White House sign off on it. Then they sent it to Homeland and they signed off on it too. And then Benny deleted the evidence that they signed off on the deletions. So Barry Loudermilk, it's this cover-up of massive proportions. Congress must properly retain and archive committee records to maintain the confidence of the American people, but they don't have that anymore at all. And to that end, Congress must be counted on to follow the rules, but they didn't. So before speaking publicly, Barry sent this. He says, "I'm requesting you respond to me and let me know," and so on. And so Barry sent this letter. Benny ultimately responded, but let's go back to the motion. So Donald Trump is asking for subpoenas. He says, that was the letter to and from Barry Loudermilk to the January 6th committee. He confirms they were not archived. But in response to Loudermilk's letter, Bennie Thompson responded, and Trump's lawyers say that Bennie Thompson, in fact, in his response, he confirmed that despite their plain relevance, these and other records were in fact not archived. Nope. Bennie Thompson says, yeah, you're right. Yeah, I do think that you're right. They were relevant, but they were not archived. All right. Bennie Thompson cryptically described as temporary committee records, whatever those are, right? So some lawyer somewhere, let's just call them temporary. That way you can delete them without saying you're deleting House evidence. So Trump's lawyers say likewise, at the very end of its existence, its pathetic, illegal, dishonest existence, every single person involved, the Select Committee, quote, loaned other crucial records to the White House Special Counsel and Department of Homeland Security. So before they turn their homework into the American people, they allow their own partisan entities, DHS controlled by Joe and the White House controlled by Joe, to filter out the report. From the descriptions in the letters, these materials include important intelligence and other law enforcement information and records identifying witnesses and other information that the Select Committee deemed, quote, sensitive pursuant to agreements with the White House and DHS. But they didn't send this over to the Republicans, did they? In truth, Trump's team says there was no, quote, loan at all. And the Select Committee's failure to archive the materials was intentional. Bennie Thompson provided the materials to the White House and DHS on Friday, December 30th, knowing full well the Select Committee would dissolve the very next business day. Look when he did it. As planned, the Biden administration did not return these documents prior to the dissolution of the Select Committee, and as a result, the Select Committee did not, quote, properly archive that material with the rest of its records. Oh my gosh. So they sent it over. Do you see what they did? They bundled it all up. They said all of this, so it's not like the White House even really commented on it or signed off on it, right? As we were reading this, it came to me like they were saying, delete that, delete that, delete that. It doesn't read like that now. It says what Bennie Thompson did is he put all of this stuff on a hard drive and then he sends it over to them on the very last day, knowing that they're not going to have time to send it back. And then the committee's going to expire. And so with the committee's expired, there's nobody to send the evidence back to. So it's just gone. It disappeared. And here are the rules. They say December 30th was a Friday. Monday, January 2nd was a federal holiday. And Congress ended at January 3rd at noon. So there was just not enough time. They just timed it perfectly. These people are so dishonest. It's actually pretty impressive how disgusting they are. So needless to say, there is a significant overlap, says Trump's defense, between the Select Committee's investigation and this case. Obviously, what the J6 committee was doing was like bootstrapping the DOJ prosecution, right? They were making the case in the court of public opinion that Trump needed to be prosecuted. They were doing things that the DOJ could not do because they were Congress. They were subpoenaing people and the courts were just stepping out of the way. What we saw was a fake show trial, really, in our own Congress, where there was no adversarial proceedings at all. No other witnesses were brought in to testify that were adversarial to the narrative. Republicans didn't get to cross-examine the witnesses that were brought in. It was all fake. So it was done to give a bundle of evidence, all the good stuff. You know, if this was an actual criminal prosecution, the government has to disclose the exculpatory materials to the defense. But Congress doesn't. Congress can go get whatever they want, and then anything that's bad, as we see here, they just delete. So Trump doesn't get to see any of the good stuff. They get to filter out all of the bad stuff for them, package it up, and then just leave it ready for the DOJ to run with. It's exactly what they did. So here, it's a lot of overlap, and so Trump's defense says, Your Honor, there is a strong likelihood that individuals discussed in these missing records that were all deleted, 1.5 terabytes, that they could be called as trial witnesses. Indeed, the letters from the Select Committee transferring these records to Joe Biden's White House and Joe Biden's homeland indicate just how important the committee considered these witnesses to be. And so Trump is fully entitled, Your Honor, to seek the missing records by subpoena. It is also equally important to determine if these records have in fact been lost, destroyed, or altered. The requested subpoenas, Judge Chutkan, are narrowly tailored to achieve these legitimate ends. We're not fishing like Bennie Thompson was. And this is fundamental to ensuring Trump's right to a fair trial under the 5th and 6th Amendments. And as missing records, as they're currently unavailable, the requested subpoenas would not be duplicative of any other records, either publicly available or produced in discovery. So don't tell us, Judge, that we can just go find this somewhere else. We can't. They say they deleted them and nobody has them. So accordingly, Judge Chutkan, President Trump requests leave to serve the requested subpoenas, which include the narrowly tailored documents that are listed below. As these records may be maintained by more than one party, they might be in multiple locations, President Trump seeks leave to send a substantially similar subpoena, very similar as we'll see, to 7 likely custodian of the requested records. NARA, the National Archives, Clerk of the House of Representatives, Committee on House Administration, which succeeds the J6 committee, Loudermilk, Fishing Bennie Thompson, the Special Counsel to the White House, and General Counsel to DHS. And here are the things they want. They want the Select Committee missing materials. So they want records and communications about methods, practices, instructions, litigation, and all the things that came to the records. What happened to the missing materials? And I really like this phraseology. Missing materials. Where is the missing materials? Nobody knows where it is. They know where it is, but the Republicans do not. So records and communications about the loss or the destruction of these materials, and communications with the DOJ or other law enforcement agencies about the missing materials. So the records also of any accommodations or agreements with the executive branch that came from the DOJ or the White House, what were the deals, and any other documents in any way that pertain to the so-called missing materials. Now they say, Your Honor, Judge Chutkan is who we're making this argument to, and so the question is, what is she going to do with it? Says, Your Honor, under the rules of criminal procedure, the court has the power, may direct that subpoenas be issued. And we know what some of the rules are. They say that a defendant's fundamental right to confront his accusers, a defendant, in this case, Trump's right to due process and a fair trial, make it important that we have the opportunity to issue subpoenas. In fact, courts have said, in many cases, the defense is at a disadvantage okay? The government, and I think this is a great point, but the government has everything, all right? In any criminal case, the government, it's David versus Goliath all day, and Goliath usually wins. It's a situation where they have everything, all the money, prosecutors, cops, the judges and everybody involved in the case, they're all getting paid from the same entity, okay? It's the government. They're on one team, and it's not yours. So the constitutional importance of allowing the defense to issue subpoenas and to do their investigation is critical. We can't deny them that. They say, so here, the defense is entitled to know, Trump is entitled to know whether evidence against him has been lost. They have all the power in the world. Separate tests may apply when the government fails to preserve evidence, and if they do fail to preserve evidence, there might in fact be a significant due process violation, and oftentimes that results in the dismissal of the case. But here, they say to obtain a subpoena, very low standards. We only need to show that it's relevant, that it's admissible, and it's specific, and Judge, we think we've shown that here. They say this is why. The subpoenas, Judge Chutkan, that we're asking for are proper under the rules because they are asking for relevant, admissible documents that are narrowly tailored to this case. We think that the requested records are critical to Trump's expected trial defense. They also are important to his right to confront his accusers and a due process. How can you prepare your case if you don't know that there might be some witnesses out there because you can't see the evidence about them? How can you say that you had the proper opportunity to prepare yourself, that you were afforded due process under this law, if you can't even see the evidence to investigate where you should go or what you should do, or a fair trial? So they say, Judge, it's obvious these subpoenas should issue. Here's why. Based on the description in the letters that we read to the special counsel and to the president and to the general counsel from Bennie Thompson and back and forth, all of that exchanges, the missing video recordings and other records that have been disappeared relate to Secret Service personnel and to witnesses that are within the purview of the White House or the executive department. And these people, they have extensive knowledge about January 6th. Records of these likely trial witnesses are critical to the defense. Now, as the letters attest, as these other exhibits show, those personnel provided very important information to the committee, these Secret Service people. And it became clear that additional interviews of certain Secret Service agents and personnel would be necessary for multiple reasons. These are in other exhibits that we fast forward through. Another Meyer letter, who's also getting a subpoena, it also discusses, quote, substantial intelligence that was communicated to the White House and to the Secret Service related to January 6th. And a big part of the January 6th issues that we have talked a lot about here, and it's not just us theorizing about this, the former Capitol Hill chief of police called Stephen Sund, he has communicated this many times, and he wrote an entire book about it, about all the security failures and about how he was running around for 71 minutes, I think, asking for permission to bring in additional support, and he was just strung out. They would not allow him to do that. So he points the finger at other people who were responsible for allowing the chaos to happen, and we want to know about that. Who was in the chain of custody? Who was in the chain of command? And Trump has a right to know, in my opinion, because how can he prepare his defense without knowing that? Pursuant to the Sixth Amendment's right to compulsory process, they say the court must enforce a defendant's subpoena when the documents are essential to the defense. And these are all about the very nature of actions for which he's being charged. They say, Your Honor, these requested records are necessary and they're not overbroad. We seek limited categories of documents, only two highly relevant topics that we want to know about. And these were records that were not retained by the committee and the ultimate disposition of those records. That's what we want to know. This is not a general fishing expedition like Bennie Thompson was doing. It only concerns a specific issue, just one, the deleted records. And they don't include documents related to anything else that the committee was doing. It's just very narrow. So Chutkan, there is a dispute within the House of Representatives over the disposition of these records, and the requested records were clearly important to their investigation. So they're important, okay? They were important to January 6th, so they're important to us. And finally, given the limited subject matter requested, the government, Jack Smith, should have very little trouble locating these documents and confirming they have no such documents, and in any event, retain the right to raise further objections. Now, I think what Judge Chutkan is going to say is that some of this stuff that they're raising here is, she's not going to care about. She's going to say, well, look, I don't have no, so like this will be a jurisdiction, right? I guarantee you when she issues a response denying these subpoenas, which she will, she'll say, it's outside of my scope, okay? The courts don't have authority over what Congress does with their records. in other words. Finally, given the limited subject matter, should be very easy for them to go figure it out. They say the requested records here are also admissible. The materials don't actually need to be used in evidence, but they could be used in evidence. And one feature of the evidence that was identified in one of the other letters here is that it could be used to show that notice to the White House personnel about the events of January 6. Show notice to White House personnel. The indictment directly alleges, so the crime is saying that Trump directed supporters to the Capitol to obstruct the proceeding, all right? So Trump gave the affirmative act. He is communicating that. The indictment is saying that was the illegal conduct. So the knowledge and the intent of President Trump is plainly relevant. And so these records could be offered for non-hearsay purposes of demonstrating a witness's or a party's state of mind. Of course, there are also impeachment materials that we could use, and to the extent the government intends to call witnesses from the Secret Service or from the White House, a subpoena here is proper. So Judge Chutkan, for the foregoing reasons, President Trump respectfully requests this court grant counsel leave to issue the attached subpoenas and require the production of records within 2 weeks of service of the subpoena, signed here by Trump's defense team, John Lauro and Todd Blanche. And now we'll take a look at the actual subpoenas. And as we saw, they're going to be very similar because they're looking for the same types of things, but very good. I like to see that they're going for this. And even if it gets denied, which I think that it will, Trump is going to say, see, I told you so. What we're going to see from Trump, and I don't want people to get too demoralized out there, are a lot of efforts that are probably going to fail. And he's going to make a case on appeal that he was denied. And each one of these denials is a major constitutional violation in some way, shape, or form that will eventually make its way up to the Supreme Court, and they'll bundle them all together and they'll come back down on appeal. But he has to etch it in now. Now, here are the various subpoenas. So just a quick refresher of who these people are. Loudermilk got one. He's from Georgia. Steele got one from Wisconsin. Sauber, Joe Biden's lawyer, got one. We've got this guy, Jonathan Meyer. He's the general counsel who got a subpoena. NARA, the National Archives, the head librarian, Colleen Shogan, got one. And so did these guys, Kevin McCumber, the clerk of the House, and Bennie Thompson. So we'll finish up with him and his fresh new subpoena right out of the oven. This is the first one, and they're all going to look very much the same, but this is what it looks like. District of Columbia, a subpoena to produce documents or information in a criminal case. And so this has not been signed off on yet by the judge, right? Judge Chutkan has not made a decision one way or the other on this, and I actually tend to think that she's not going to sign maybe any of these, but we'll see. But they're attempting to do it so that when they get denied, they have a basis for appeal. So it's very simple. They say here, this one, to Barry Loudermilk, United States House of Representatives. You are commanded to produce at the time and place the following books. See the attachment in Attachment A, and let's take a look at Attachment A. Here, your Loudermilk communication records. So all the things, the Meyer letter, the Loudermilk letter. So this is Kevin McCumber. He got the same thing, all right? Jonathan Meyer, he's over from Homeland Security. He got one. This one went to Joe Biden's lawyer. This is Richard Sauber. This one is for the National Archives, going over in Maryland to Colleen Shogan, and that's a big one. That we really want to see that one. This one goes over to Brian Steele. He's on the House Administration Committee. And then the last one, my friends, the big one, goes to Fishing Bennie Thompson. Boom! Subpoena has been drafted. Let's hope it goes over to him. Now, of course, Congress people are going to say, I'm also legislatively immune from this. And we'll see if the judge signs it, but we're looking for Chutkan to sign off right there. But this is what Bennie Thompson is going to be getting theoretically, or what is just right at his doorstep. And here are the instructions for Bennie. Hey, Bennie, couple things you got to do here. Submit all the materials back over to the Lauro law firm. You got 14 days to do it. You better get all the stuff that were kept in the usual course of business. Make sure that if you're asserting a claim of privilege, you tell us what type of privilege. And if any record has been destroyed or discarded, you better let us know how. Tell us about the date of the destruction, how it was destroyed, and the reason why you destroyed it, and the identity of the last custodian as well. So this is what they want. All of the missing materials, all the records for holding and transferring the materials, any communications with the DOJ, the White House, and so on. And so that is a lot lot of fun. Now, I'm very hopeful that the judge signs off on it. I am not optimistic about that actually happening. But as I said, the point is to confirm that Trump is not being afforded the tools that a regular defendant would be afforded. Your Honor, you're charging a former president, okay? The reason we're asking for documents from Bennie Thompson is because Bennie Thompson was highly involved in this case. You're saying there was a conspiracy and there was all this activity going on. He was involved. Just like if you're charging a street-level drug dealer, his subpoenas are going to be for other people who might be useful to his case. So we'll see where this goes, and it is going to be a lot of fun to continue to follow. And as Trump continues to crush Biden in the polls, we're going to see what else they do.